I'd like to introduce Tim Garden. Tim is a past chair of the ISBA real estate section, and he frequently speaks on real estate topics and title topics. I'm going to turn it over to Tim at this time.
Great, thank you, Christy. So any one of us could go back to our office. If you're in your office, you get the mail, and in there is an envelope from the disciplinary board. And you open up that envelope and you find that there is a letter describing a transaction that you advised several years ago, and that's now been determined to be fraudulent. And the question now for the disciplinary board is whether your participation in that transaction was itself fraudulent. That's a pretty serious question, and that's the topic that brings us here today. The Iowa Bar Association has also thought it was important enough to make this a webinar for the entire state. Now, a couple of administrative things before we get into today's material. First of all, I encourage you to print your outline, because as we go along today, there'll be some things that you'll want to mark up as we go along. Now, a couple of thank yous are in order. First of all, Christy Cronin is the person who introduced me today, and for the last 15 years she's been on staff with the bar, and she is principally responsible for putting on these CLEs. We owe her a great deal of thanks for making sure we have CLEs to help us grow as attorneys and better take care of our clients. And so a word of thanks to Christy. You can clap for Christy. You can do that. And if you're there at your office and your computer, you can clap for her. In case you're curious, we can see you. The cameras on your computer have been turned on so we can see you, and if you don't have a camera, Christy installed a camera in your audience. So I actually have a bank of screens off to the side, and I can see what you're doing. And that's true. I wouldn't make that up. So thank you, Christy, for your work and for putting these cameras in all of our offices. I also want to thank Pat Bauer at the University of Iowa College of Law. This was actually his idea that I take a look at the Ouderkirk case, because he recognized the significance of this for Iowa lawyers. Between you and me, I actually didn't really pay attention to this case when it came out, and only in further review I realized how significant that it is. So thanks to Pat Bauer. Again, if you have questions, feel free to pose those questions as we go along. I would appreciate if you only ask questions where I know the answers. So if you have questions I clearly won't know the answer, send those to me by email later on. So to turn our attention to the material, the case begins with this quote from Justice Waterman. His question: how far can a lawyer go to assist a client in preserving assets from a potential creditor? The Ouderkirk case is a 2014 Supreme Court case, and is a case of first impression. And I think most people would say when they read this case that clearly this is a close call, that reasonable people might have seen the outcome turn out differently. Because it is a close case, I frankly think that makes it a more valuable precedent for us. If it was a slam dunk, then it wouldn't be as helpful for us going forward. So I do think that it's a case of great significance for us. And in my outline today, we're going to take a look at three questions. One is, what does the Ouderkirk case say for defining the boundaries of attorney conduct in advising clients in asset protection? Number two, what are the broader implications for Iowa attorneys? And then third, we're going to look at what are called the badges of fraud tailored with respect to residential real estate closings. Now, if you're thinking, okay, I'm not a real estate lawyer, I can check Facebook when I get to that part of the material, stay tuned, because I actually think that there will be material in there, even if you're a tax attorney or strictly an estate planning attorney or family law, that you'll find some carryover into your practice areas. So where are we going today? First of all, I need to give you a little bit of an on-ramp with respect to the legal context of the Ouderkirk case. We'll look at the rules of ethics that were in force at that time. I have a few thoughts about fraud, and then we'll look at the facts of Ouderkirk, the issue on appeal, the arguments that were made by the attorneys in their appellate briefs, and then we'll look at the Ouderkirk holdings, rationale, and then the implications of the case. Now, I have to give a little bit of word because when we talk about an ethics case, it's a little different than other cases, in my opinion, because we're talking about one of our own. I have not met Mr. Ouderkirk, and this case says very good things about him. He has a stellar reputation. He's practiced for over 35 years, and it is now my understanding that he serves on our Board of Governors for the Iowa Bar Association. And so he has a great deal of esteem in our state. So nothing that I say today or in my material should be construed as any kind of concern. He went through a lot in going through this exercise, and nothing I say should be any kind of a derogatory comment about Mr. Ouderkirk. So let's talk a little bit about the legal context of this case. For those of you who have the same level of gray hair as I do, or maybe a little more, we were trained on the Iowa Rules of Professional, the Iowa Code of Professional Responsibility for Lawyers. Those are the DRs and ECs. Well, it's funny, we think that we shouldn't be dealing with any more cases that deal with that body of ethics, because in 2005, Iowa adopted the Iowa Rules of Professional Conduct. And that's what's been in place now for some time. So we're going to go back in time a little bit, because the facts of this case take place in 2003. So it's not the new rules, but actually the old rules that apply. Now the good news is that I believe that the Ouderkirk case certainly applies in our current context, because the material language of the old rules was carried over into our new rules. So a little bit of primer on the Iowa Code of Professional Responsibility. Now, there were 4 rules that Mr. Ouderkirk was alleged to have violated. DR 102A4, conduct involving dishonesty, fraud, deceit, or misrepresentation. DR 102A5, conduct prejudicial to the administration of justice. DR 102A1, action to harass or maliciously injure another. And DR 102A7, assisting a client in fraudulent conduct. And so I've given you the language here. This is the actual code sections. 102 provides that a lawyer shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, nor should the attorney engage in conduct that is prejudicial to the administration of justice. Then DR 102, this deals, a lawyer shall not file a suit, assert a position, conduct a defense, delay a trial, or take other action on behalf of a client when the lawyer knows or when it is obvious that such action would serve merely to harass or maliciously injure another. And finally, number 7 there, counsel or assist a client in conduct the lawyer knows to be illegal or fraudulent. Now I want to at least show you the carryover on the fraud with respect to the Iowa Rules of Professional Conduct. 3284 says it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. That's the same language as in the other rules. And D, to engage in conduct that is prejudicial to the administration of justice. A couple thoughts on fraud. When I was working on this pretty heavily for the presentation that I gave last September at the University of Iowa College of Law Real Property Seminar, it was interesting. I happened to be reading a book that had been on my to-read list for some time. And you can see it here. I was reading The Common Law by Oliver Wendell Holmes Jr. This is the book that talks about how the life of law has not been logic, it has been experience. And I had never read this thing. And I thought, okay, it's time I check this off the list. And I came across this paragraph. And it is mind-boggling how relevant this paragraph is to our material today. I want to take just a second, take us back to look at a little bit of Justice Holmes. He says, it is not true, as it is sometimes said, that the law does not concern itself with the motives for making contracts. On the contrary, the whole scope of fraud outside the contract is the creation of false motives and the removal of true ones. And this consideration will afford a reasonable test of the cases in which fraud will warrant rescission. It is said that a fraudulent representation must be material to have that effect. Look at this language. But how are we to decide whether it is material or not? If the above argument is correct, it must be by an appeal to ordinary experience to decide whether a belief that the fact was as represented would naturally have led to, or a contrary belief would naturally have prevented the making of the contract. Now, the Supreme Court of Iowa did not rely on Justice Holmes when rendering its decision, but it certainly could have, because much of what this case involves is whether Mr. Ouderkirk understood what Mr. Heemstra was doing in a particular contract. And we'll double back on Holmes later on. Quite fascinating. I almost fell out of my chair when I read that. Page 6 of the outline takes a look at Iowa Code section 684.4. If you're not familiar with this code provision, you really need to be, because the code sets out the process and the factors for potentially overturning a transfer. So 684.41, a transfer made or obligation incurred by a debtor is voidable as to a creditor, whether the creditor's claim arose before or after the transfer was made or the obligation was incurred. Very important to note the timing of that. If the debtor made the transfer or incurred the obligation with any of the following circumstances. A, with actual intent to hinder, delay, or defraud any creditor of the debtor. Now in subsection 2, you want to read that together. In determining actual intent under subsection 1, paragraph A, consideration may be given, among other factors, to whether any of the following apply. Now this list is a codification of what are called badges of fraud. And we're going to talk a lot today about this concept of badges of fraud. And basically it's the idea of factors that would tend to indicate that there is a fraudulent transaction. So the language doesn't say these are badges of fraud, but that's what they are. And I want to just do a quick scan of these because this is all important to have as background as we approach the Ouderkirk case. First, the transfer obligation was to an insider. The debtor retained possession or control of the property transferred after the transfer. The third one, the transfer or obligation was disclosed or concealed. Fourth, before the transfer was made or obligation was incurred, the debtor had been sued or threatened with suit. 5, the transfer was substantially all of the debtor's assets. 6, the debtor absconded. 7, the debtor removed or concealed assets. 8, the value of the consideration received by the debtor was reasonably equivalent to the value of the asset transferred or the amount of the obligation incurred. Next, the debtor was insolvent or became insolvent shortly after the transfer was made or the obligation was incurred. Next, the transfer occurred shortly before or shortly after a substantial debt was incurred. And finally, the debtor transferred the essential assets of the business to a lienor that transferred the assets to an insider of the debtor. That's a pretty extensive list that the legislature has given us. This is a help to us as we think about transactions. It becomes sort of warning signs for us. The creditor has to prove these elements by a preponderance of the evidence. Now, it's interesting to note that the Iowa Code of Professional Responsibility did not provide a definition of fraud. But the Iowa Code of Professional Conduct now does provide a definition of fraud. We're on page 7 of the material, and that is fraudulent if it's fraudulent under the substantive or procedural law of the applicable jurisdiction and has a purpose to deceive. A final point about fraud, and again, thanks to Pat Bauer for bringing this case to my attention. It happened to be recently that we have a U.S. Supreme Court case, Husky International Electronics, Inc. versus Ritz, and this is a bankruptcy case. And the issue before the court in Husky International was how the term actual fraud was to be construed within the bankruptcy code. One side was arguing for a more limited use of the term, and another side a more expansive form. And the majority held that the term could encompass fraudulent conveyance schemes, even as such schemes did not include an element of false representation, and this is the part to underline, to a particular party. So this was a more expansive concept of fraud, and again, that's going to come back to Ouderkirk in our discussion today. So that's the background, the legal framework of the Ouderkirk case. Now for the facts. As I mentioned, Mr. Ouderkirk has practiced, at that time he had practiced over 35 years and has a reputation for being a zealous advocate and had an AV rating from Martindale-Hubbell. So he was a very esteemed attorney at the time this took place. On January 13th, 2003, Rodney Heemstra shot Tommy Lyon in a dispute over farm ground and hid his body in a cistern. Now the chronology of all this is important to have a sense of. So January 13th, 2003. 2 days later, Mr. Heemstra was arrested and charged with murder in the first degree. And Mr. Ouderkirk began to represent Heemstra and began assisting with preparation of documents to transfer millions of dollars of assets. That started on January 15th, so right away as soon as Mr. Heemstra was arrested. On January 16th, the next day, Mr. Ouderkirk writes a letter to Mr. Heemstra's wife. Her name was Berta. And in your material, I want you to take a look at page 8 of your outline because I think this letter is extremely important. This is in the third full paragraph. He also alerted Berta that if any of the family property was transferred, quote, the Lyon family may attempt to set aside any conveyance as fraudulent or an attempt to avoid a creditor, and noted, should a court deem the conveyance fraudulent, there is always a possibility that the conveyances could be set aside. This letter is very important because it does two things. First, it provides important notice right away to the Heemstra family of the risk that the conveyances that he was assisting with incurred. But it also gives us an indication of what Mr. Ouderkirk understood. In other words, he wasn't a lawyer that didn't have any concept that it wasn't fair to hide the assets if there was a potential claim. Mr. Ouderkirk had a full understanding that these conveyances might be undone by a creditor. Mr. Ouderkirk should be commended for this letter. January 21st, Mr. Heemstra is released on bond, and on January 27th, just a couple weeks after the murder, a wrongful death claim is filed. Now, I think this is unusual. Normally, a wrongful death case is not brought so soon after the crime takes place. Typically, the plaintiff wants to wait until the criminal action takes place, discovery is done through that, and then the wrongful death suit is brought. And I don't have any inside knowledge as far as what motivated the wrongful death suit to be brought so soon, but one could probably presume that there was some kind of incentive, that there was some kind of recognition that they better get this thing filed in order to protect assets. Thank you, Christy, for, I think I was falling off the earth. Appreciate that. Now, between January and February, again, we're still in 2003, Heemstra told Ouderkirk that the purpose of these transfers was to assist with cash flow. There was a lot of debt, there was a need for restructuring, and that was the reason for doing all these transactions. 4 trusts were created, and over 1,000 acres of land were conveyed. At this time, Mr. Heemstra was worth in excess of $4 million. Now, of all the transactions that Mr. Ouderkirk assisted with, there was really only one that was the fodder for analysis in this case. On March 26th of 2003, Mr. Ouderkirk assisted with the preparation of a contract for 600 acres of land worth approximately $2.3 million. And the entities involved Briscoe Revocable Trust, which was a trust that Randy Heemstra's wife, Berta, was the trustee of, to an entity called Appleroon Irrevocable Trust. Mr. Ouderkirk stated that he did not know anything about the Apple Room Irrevocable Trust, who was behind it. He was simply involved to prepare this transaction, and he prepared it at the direction of Rodney. Now, turn in your materials to page 11 of your outline, because this case turns on paragraph 26 of this contract, and so we really want to understand this. And we should also take a look at the paragraph earlier on that page. Yet only a week later, the Heemsters told Ouderkirk that they had found, through an arm's length transaction, an unnamed, bona fide, out-of-state buyer for much of the land now held by Briscoe, the Appleroon Irrevocable Trust. Ouderkirk knew the Heemsters had previously listed the property for sale and believed the sale was nothing out of the ordinary. Ouderkirk did not ask and was not told who was behind Appleroon. In fact, Rodney's sister was the initial trustee of Appleroon, and the successor trustee was Rodney's cousin's wife. The Heemsters' two sons were the beneficiaries of the trust. So you see where we're going with this? This is a transfer from basically one family trust to another. So let's take a look at paragraph 26. Now, my presumption is that nobody here has a standard real estate contract with anything like paragraph 26. So this is a paragraph that was tailored for this matter. Take a look at this. This is what this whole case is about. Buyer acknowledges that the Iowa District Court for Warren County has issued a writ of attachment in a pending lawsuit entitled The Estate of Tommy Ray Lyon versus Rodney Heemstra, which may be purported to affect title to the real estate described herein, even though Rodney Heemstra is not a party to this transaction. Technically, that was true. Seller and buyer are of the opinion that said attachment does not affect the real estate which is the subject of the contract because it was not in effect and or filed against the premises at the time seller acquired title to said real estate. This is the part you want to underline. Buyer shall suspend and not make any payments due to the seller which are attached, garnished to be paid to, executed upon, levied upon, and or assigned by, to or for the estate of Tommy Ray Lyon or its personal representative, the surviving spouse, heirs, or devisees of Tommy Ray Lyon, or successors or assigned to the same shall be added to the principal balance due in the final payment due seller on April 1st, 2033 under this contract, but shall not draw or accrue additional or delinquent interest on said deferred payment amounts. Seller shall defend, indemnify, and hold buyer harmless for any losses, damages, or any monetary sums arising out of such actions, claims, or actions. And it's important that this paragraph specifically names the Tommy Ray Lyon estate because there were other creditors involved. So we're particularly selecting one creditor. Now, Mr. Ouderkirk was not involved with his closing. And I should say as well that Mr. Ouderkirk had represented the Lyon family during the 1990s and assisted with preparation of various real estate documents, but the Heemsters did their own closings. Sort of interesting. My clients don't do their own closings, and Mr. Heemstra did his own filings. By the late March of 2003, Mr. Ouderkirk was no longer representing Mr. Lyon on the Murder One case. New counsel was brought in. So what happened then? Well, Rodney was convicted of murder in October. Again, we're still in 2003. And by the time we get to 2006, February of 2006, now we have a wrongful death judgment, $8.9 million judgment. But as you may remember from this time, this Heemstra case just seemed to drag on forever. It's a case that would never end. Then in April of 2007, there was a retrial, and Rodney was convicted instead of voluntary manslaughter. Then, of course, we had to take another bite of the apple at the wrongful death. In November of 2008, the wrongful death judgment was reduced to $5.7 million. Now, right away when the estate got the judgment in February of 2006, they started making efforts to collect on the assets. And by the time we get then to September of 2008, when the wrongful death final judgment was put in place, there was a 70-page ruling that came from the district court. And it's quite an opinion. And just to give you a flavor of this, turn to page 13 of your material. And I want to give you just a flavor of this. The court specifically addressed paragraph 26 of the Briscoe to Appleroon contract, concluding it established Berta's absolutely fraudulent intent. The court stated Rodney and Berta Heemstra were willing to forego any payment, including interest, for up to 30 years, rather than have any of his assets made available to satisfy any debt owed to Rhonda Lyon or the Tommy Lyon estate. In sum, the district court found, listen to this language, the conduct of the defendants, Rodney and Berta Heemstra, was oppressive and conniving. It was not only an intentional failure to discover or prevent the wrong, but an intentional, concerted, and protracted effort to cause the wrong. It was conduct motivated by greed. The nature and complexity of their scheme shows that their conduct was far more than a willful and wanton disregard for the rights of another. It was the intentional, harsh, and cruel effort to put truth in Rodney Heemstra's arrogant claim that Rodney Lyon would never see a dime of his money. He made that promise to the widow of the man that he killed. That's amazing. But the matter didn't end there. So remember, this all started January 2003. Now, in December of 2009, a complaint was filed against Mr. Ouderkirk for his involvement in the Heemstra matters. In December of 2012, look how long this time is going on. December of 2012, we now have a hearing before the Grievance Commission. And in July of 2013, we get the result. And I want to give you just a flavor of this. And if you have the Ouderkirk decision, it's actually an attachment. It's Exhibit 1 to your outline. It's on page 39 of the Ouderkirk case. And I want to give you just a flavor of this. The commission found Ouderkirk reasonably believed the explanation that Heemstra gave as motivating the transfers into the revocable trust. Accordingly, the commission concluded Ouderkirk did not know he was facilitating a fraudulent conveyance by assisting the Heemstras in transferring property into revocable trusts. That's good. The commission did, however, conclude Ouderkirk violated DR 102A4 and DR 7102A1 by creating the transfer documents to convey the Heemstras property to Appleroon. The commission found credible Ouderkirk's testimony that at the time he drafted the Appleroon contract, he was unaware of the identity of the buyer, the familiar relationship between buyer and seller, and the fact that the buyer was not bona fide. Yet paragraph 26 of the Appleroon contract convinced the commission that Ouderkirk should have recognized the Heemstra's illegitimate motives. The commission viewed paragraph 26 as an obvious attempt to shield the Heemstra's assets from the estate and noted the language of paragraph 26 was tellingly absent from the other real estate transfer documents Ouderkirk created. The commission highlighted the fact that Ouderkirk had warned the Heemstras against creating an irrevocable trust shortly before drafting the Appleroon transfer documents. The commission concluded the record lacks a defensible reason for the transfer from a revocable trust into an irrevocable trust. Deeming Ouderkirk's actions an isolated and uncharacteristic lapse of his professional judgment, the commission faulted Ouderkirk for failing to recognize the red flags of a fraudulent conveyance. So there was one finding of fault, and there was a recommended sanction of a public reprimand. And that's what was appealed. Okay. Now, So that was what was appealed to the Supreme Court. Now, I don't normally pull appellate briefs when I'm reviewing a Supreme Court case. But because of the magnitude of this Ouderkirk decision, I thought this was a valuable exercise. So I obtained copies of the respective appellate briefs. And if you have an interest in this, please let me know. I'd be happy to email them to you. I think both briefs are well written, and I want to give you just a flavor of these briefs to get a sense of how this case was being framed up for the court. First of all, I want to take a look at the brief written on behalf of Mr. Ouderkirk. Now, obviously, he's claiming that he did nothing wrong and that there couldn't have been any finding of fraud on his behalf because he did not have any contact with that potential buyer. Now, let's take a look at the language, and I've cited this. We're on page 14 of my outline. And this language is really well done. In hindsight, it's always easier to see what might have been done differently under certain circumstances, and every attorney has cases and causes they wish they had done differently. This court has never held attorneys, nor have the ethical rules, held attorneys to a standard of perfect hindsight. That makes sense. What is it about this deal that assures the board that in this case it isn't about just perfect hindsight, that Ouderkirk had Ouderkirk just asked the right questions, he would have drafted the subject document. He would not have drafted the subject document. Why does the board believe that Ouderkirk asked the right questions? Had Ouderkirk asked the right questions, his clients would have been candid. On the board's theory, does Ouderkirk have a duty to look further into the buyer's background? Does he have an obligation to do a credit check? To get banking references? Where does the attorney's obligation end? And I think that's a really good question. It's haunting, isn't it? Where does our obligation end? Let's take a look at the brief written on behalf of the Iowa Supreme Court Attorney Disciplinary Board. They're arguing, in essence, that Mr. Ouderkirk's approach was one of willful blindness. I grew up watching Hogan's Heroes, and you may remember that show had a very prominent character in Sergeant Schultz. And Sergeant Schultz was always saying, what? I hear nothing, I see nothing, I know nothing. So the Sergeant Schultz approach to practicing law. I've just lost about half of my audience, Christy. Are they still there? Are they all, half of them logged off? I have no idea what Hogan's Heroes is about. Maybe I shouldn't use that reference. Can we start again? No? We can't start again? Okay. I want to take a look at just one paragraph of the brief. The conduct described in the complaint in this matter is a prime example of why so many members of the public hold the legal profession in such low esteem. Attorneys who have clients who commit crimes and/or torts should not respond by transferring the client's property via quitclaim to a relative for no consideration to avoid potential creditors. They're right. Lawyers shouldn't do that. And it is sad when lawyers get a bad name for these kind of things. It makes us all look bad. So this is how the case is framed up for the Supreme Court. What is the Supreme Court going to do with this case? So let's turn our attention now to the holdings and rationales of the case. Now, the first thing the court had to deal with is this question of whether the fraud had to be aimed at a particular person. Was the court going to apply a common law definition that required all of those standard elements? And the court resolved this by reliance on a case called Jacobson. In the Jacobson case, this is on page 16 of my material, the Jacobson case involves an attorney who prepared a sham mortgage and recorded it as a way of warding off potential creditors about the availability of assets that were available. Pretty creative thinking. Here's a piece of real estate. It might be a prime candidate for a potential judgment to attach to. I know what we'll do. We'll just create a mortgage that's bogus and make sure that the creditor doesn't have access to that, doesn't view it. as a potential asset. And the court said that no, we conclude assisting a client with a fraudulent transaction can, in the appropriate circumstances, constitute a fraud under our disciplinary rules. So that's one of the first takeaways for us as an attorney, is that if we assist clients with a fraudulent transaction, it can be considered an ethical violation for us to do that. Right? So that more expansive concept of fraud that Ouderkirk was fighting against, that's what the Supreme Court took on. I also note Iowa Rules of Professional Conduct 3210 defines fraud more expansively and would include fraudulent transactions rather than the more limited common law definition that Ouderkirk wanted us to apply. The next holding, an attorney has a duty to a client's creditors. Mr. Ouderkirk argued on appeal he had no duty to the creditors of involved here of the Heemstras. In this argument, the Supreme Court made a bit faster work because actually there was a rule that particularly addressed that, and that was EC 710. And that provided that, in fact, attorneys do have a duty to the creditors of our clients. Section C there on page 17, an attorney can assist with a client with asset protection even if there's a possibility that the transaction could be set aside. Now, this is an important thing for us. Now, an attorney cannot knowingly assist, but we can participate in preparing transactions even if there's a possibility that down the road those transactions can be set aside. And it's important to know fraud is not presumed by the court. The attorney cannot always read the client's mind. But the court made it very clear that no excuses are available to the attorney in the event the attorney knows about the fraud. For example, the attorney can't say, well, I was just a scrivener, or everybody else is doing it, or I was only doing this at the direction of my client. None of those are going to be excuses for the attorney. Then we have the question of whether the board met its burden of proof, whether Ouderkirk violated DR 7102A1, action to harass or maliciously injure another. And the question here is whether Ouderkirk actually knew or whether circumstances allow the inference of knowledge because of the circumstances. And the court said very clearly, an ostrich-like or Sergeant Schultz-like head-in-the-sand approach does not immunize attorneys from an inference of actual fraud. So this is very interesting. In some circumstances, the facts will allow an inference of fraud. The disciplinary board argued that paragraph 26 was sufficient to form that basis of an inference. I want to just run through one more time, just take a look at the arguments. The Lyon family was the only creditor named in paragraph 26. Second point, depriving the Lyon family of the property would harass or maliciously injure the Lyons property, and that Ouderkirk's conduct would have been willful blindness. Now, Mr. Ouderkirk's side brought on Greg Kenyon, one of the most respected lawyers in Iowa, as an expert witness, and that was a good move. Mr. Kenyon offers some very interesting insights to this, and I think this is fascinating. What Mr. Kenyon argues is that there were lawful purposes to doing exactly what was done in paragraph 26. And specifically, in addition, the reference to the Lyons family in paragraph 26 would serve to put potential buyers on notice of the claim. This reinforced Ouderkirk's contention that the transaction was arm's length because it would have been unnecessary to provide such a recital if it was only among the Heemstras. I frankly think this is a brilliant argument by Mr. Kenyon. So if this really was sort of a behind-the-back pass from one family member to another, why bother with paragraph 26? So actually that argument that paragraph 26 is an indication of fraud, Mr. Kenyon poses, no, actually it's the other way around. He turns the sword around and says, no, actually it's an indication of an arm's length transaction. I think it was brilliant. Now, there were facts the court found that Ouderkirk had a colorable basis to proceed. Again, Heemsters were under financial pressure. They had regularly bought, sold farmland. The property had been previously listed for sale. The Heemsters were indebted. And the collection efforts were largely done without Mr. Ouderkirk's involvement. Page 19 of my outline. This is important. The court notes, hindsight is 20/20. Lawyers are to be judged based on the information available to them at the time of the challenged transaction. Does this sound familiar? Sounds like Justice Holmes. The court then went on to provide a badges of fraud analysis. Now, when we talk about badges of fraud, the United States Supreme Court in a case from 1994 provided the history of badges of fraud. And this actually comes from England, and the first reference to this is from 1570. And I sort of like this stuff. I will note this year marked the passing of one of our esteemed colleagues, Bill Bartine. And if you knew Bill Bartine, he was a great lover of history in general and the history of law in particular. And Bill Bartine would have loved the analysis that the Supreme Court did about the history of the badges of fraud. So I want to note that about our friend Bill. So the court listed these badges of fraud that they applied in this particular transaction. Note these with me. Inadequate consideration, the transferor's insolvency, pendency or threat of third-party creditor litigation, secrecy or concealment, departure from usual business methods, reservation of benefits to the transferor, and the debtor's retention of the property. Pretty serious, because this sounds very similar to the kinds of things that are happening there with Heemsters. A footnote 27 is designed to be a survey of cases under Iowa law that deal with badges of fraud. I read them all, and they were quite interesting, and provided some of them to you here if you have an interest in going into this a bit longer. I do want to bring up one of these. And near the bottom, there's this fascinating case from 1920. And if we had more time, I'd go into the material elements of that case. But I want to just read a little bit of a letter from that case. Dear Uncle, if I remember correctly at the time we gave you the mortgage, you remarked that you might not put it on record. If you have not done so, I think it best that you should at once, as we are likely to have some financial difficulties in the near future. Yours truly, S.W. Snyder. Now, after a brief discussion of the merits of this case, the court held this. This opinion is already too long. It's only 4 pages. And the Supreme Court said it's already too long of an opinion. Without further detail or discussion, we reached the conclusion that the decree of the trial court was right. It is therefore affirmed. I just love the fact the Supreme Court had the ability to observe about itself that its opinion was already too long, and it was about a 4-page opinion. I miss those days of brevity. Okay, back to our material here. On page 20, this is where it all comes together, and the Supreme Court does its badges of fraud analysis. So this is really important. Page 20 of the material. For the revocable trust transfers, even though they were to relatives, Rodney did not abscond, and to Ouderkirk's knowledge, there was no insolvency, no secrecy or concealment, and no departure from the Heemsters' usual business methods. For the Apple Room conveyance, which Ouderkirk believed to be an arm's-length deal for consideration, the only badge of fraud was the threat of third-party creditor litigation. The conveyances, therefore, appeared legitimate. Ordinarily, proof of more than one of these badges will be necessary to warrant an inference of fraud in a transaction. Notice this language. Though Ouderkirk recognized a risk that a court might deem the Heemsters' conveyances fraudulent, he satisfied his duty by warning the Heemsters of that risk. So remember that letter that Ouderkirk wrote on January 16th to Berta Heemstra, alerting her of the risk. The court comes back and says, that was well done, Mr. Ouderkirk. That satisfied that duty. That's a good takeaway for us. So because only one badge of fraud was found, the only badge we found was this threat of third-party litigation, there was no inference of fraud. And also then no finding of scienter. Pages 21, I'm just going to just mention that there were these other elements that the court found that the disciplinary board had not met its burden of proof. No need to go into that. So we've covered the holdings and rationales of the court. What do we do with this? So what? What principles do we gain from the Ouderkirk case? Number one, if an attorney assists a client with a fraudulent transaction, this can constitute fraud for purposes of an ethics violation. Please understand, this can be something that we're subject to. Right? Number two, attorneys owe a duty to the creditors of their clients. Court reinforced that. Third, attorneys can assist with asset protection even if there's a possibility that the transaction could be set aside. Right? That's okay. Number four, if there is actual knowledge of fraud, there are no defenses available to the attorney. An attorney can't, number five, an attorney can't take an ostrich-like head-in-the-sand approach. The circumstances may permit the inference the attorney knew or should have known about the fraud. The facts may require a reasonable attorney to inquire about the motives of the client. And I want to pause here. This is where the challenge comes in for us as attorneys to navigate these waters. So if there is an indication of something that isn't lining up, the attorney can't just say, I don't want to know about this. The facts may warrant the attorney to go further into the weeds about the motives of the client. Number seven, the court evaluates the conduct of lawyers based on the information available to them at the time of the challenge transaction. 8, the court conducts a badge of fraud analysis. Proof of more than one of these must only be shown. And you need to familiarize yourself with these badges of fraud in your particular area. Now, I'm not a tax attorney, but I did some research, and lo and behold, the IRS has a list of the badges of fraud that are important for a tax attorney. So if you have a tax practice, Exhibit 2 provides a list of those badges. If you're a family law attorney, or if you're dealing with elder law or estate planning, you need to be familiar with the badges of fraud that apply in your particular area. Number 9, to determine scienter, the court must find the lawyer's conduct must be to mislead rather than to inform. Now, we've been talking about some pretty high-level things here, and I want to go now into some real practical pointers from this case. Number 1, documentation. When I have the opportunity to train new lawyers, I love to talk about the importance of documentation, and I have 2 poll stars in mind when I take notes when I meet with a client. Here they are. Number 1, I presume that I will not remember the important aspects about that conversation. I just won't. And number 2, I'm going to be sued. Right? Now, that may be sort of a negative way of looking at that task of taking notes. But when I sit down, I presume those 2 things. And I recommend that if you're a newer attorney, or if you have the opportunity to work with newer attorneys, you help them to learn to take good notes and develop good habits of documenting things in your file. Very important. A second point on documentation is the practice of writing follow-up letters to our clients. That was something that Mr. Ouderkirk did, and I'm sure he is very happy that he had that copy of that letter that he sent to Heemstra's in his file. And we want to just have that as a discipline. And it's never convenient to do this, right? We know, you know what, I probably should write a letter, but I get busy and then you forget to do it. You want to develop a discipline of knowing under what circumstances there really needs to be a follow-up letter to confirm things of importance to the client. Number 2, and this seems funny to have to put this in an outline, but honesty truly is the best policy. That sometimes we're in situations where things get gray, And we need to remember that pole star, that honesty is the best policy. Number 3, you can assist with asset protection. You just have to know your limits. 5, if things don't add up, seek advice from other attorneys in the area. They may have awareness of other red flags that you might not be aware of. Number 7, in a major transaction or one where there is at least one badge of fraud, I think it's very helpful to have another attorney on the other side. There is one aspect of this case that's a little spooky for me, and that is in the Apple Rune transaction, Mr. Ouderkirk did not have the opportunity to deal with a lawyer on the other side. Who transfers $2.3 million of farmland where there's not another lawyer on the other side? And so if something starts looking a bit awkward, that's really an occasion where if you know there's another lawyer on the other side, that can really help to safeguard against those kinds of concerns. The next one I want to mention, number 8, I love CPAs. So I'm a transactional attorney, but I don't have a tax practice. So I rely very heavily on CPAs. Having a CPA involved in the transaction can simply be another set of eyes and ears to help make sure that everything's on the up and up. And the last item there, you want to discuss these things in your firm. If you have newer attorneys, they're more vulnerable to making mistakes. So if you have younger associates or attorneys in your firm, or if you yourself are a younger attorney, be aware that there is a season of vulnerability, and you want to have lawyers that you can reach out to talk to serve as sounding boards. Page 24. I want to turn our attention now to the subject of real estate closings, and we're not going to have a chance to take a lot of time with this. Christy, do we have questions or comments? Okay. I'm going to just touch on a couple of highlights in this material. And if you're a real estate lawyer, you're going to want to spend some time with this. Mortgage fraud has a very simple definition, and that is it's any information that's provided that's false to a lender. Very easy definition. There are 2 kinds of mortgage fraud. Fraud that is utilized to get property, and fraud that's utilized to get money. And it's very interesting. The Treasury Department provides this fascinating data on page 25. They actually keep track of what are called suspicious activity reports, SARs. And I provided you there the data on the types of fraud by percentage and category. I think it's sort of interesting. In terms of paying attention to fraud at closing, as attorneys we have duties, both contractual and ethical obligations to our lender clients when we're closing for them. On page 26 I provide examples of various kinds of mortgage fraud that I've personally seen and I'm aware of. On page 27 I want to bring to your attention a couple of resources. On section E, number 3 in particular, because as real estate lawyers I believe we have a duty to be paying attention to types of mortgage fraud that are happening around the country, because eventually they make their way to Iowa. One that I particularly find helpful is mortgagefraudblog.com. This is an attorney who has made it sort of her life's work to pay attention to this, and she provides a fantastic website that scours the country for examples of mortgage fraud to help us understand what's going on out there, because the weasels are always trying to find new ways to cheat. And so this is a website that I have found through the years to be quite valuable. So typically once or twice a year I'll pull it up and just scan it to see if there are any new types of fraud that I should be paying attention to. What do you do when you find examples of fraud? Well, you want to provide documentation. You want to find someone of some authority within the lender. Sometimes I've talked to the frontline person. I said, look, there's something here that's not lining up. And I've literally had people at lenders, even brick and mortar lenders, say, Tim, we just prefer that you ignore that. Now, I don't have the option to do that, right? So sometimes you have to climb the ladder and find someone who's willing to take responsibility. Frankly, I think you should also contact the Iowa Attorney General's office The Iowa Attorney General's office has taken a proactive stance in pursuing these things. And I am sad to say that, in fact, there have been real estate lawyers in Iowa who have been disciplined for the area of mortgage fraud. So this is not a hypothetical. Unfortunately, this has happened here in Iowa. As we wind our time down, I want to tell you a story. When I first started practicing many years ago, I was doing some criminal defense work, and I was appointed to represent an individual who was accused of stealing some material from his employer. It was a construction company. And the plea negotiations weren't going particularly well. And eventually we were set for trial. And I was more than happy to make the state prove up its case. The state had some weaknesses, and I was happy to do that. But on the eve of trial, my client said, well, Tim, I have a theory that I'd like to present to you. You see, he had told me along the way that he, in fact, did take this material. And as a result, he would not be allowed to testify. But he said, I've got this theory that I'd like to propose and I'd like to testify, basically commit perjury. I said, the only problem with that is that as soon as you say anything that I know to be untrue, I have an ethical duty to withdraw as your attorney. If you'd like to have that experience in trial, having me withdraw as your attorney, be my guest. And he said to me, Tim, I thought you were my lawyer. Whose side are you on? And I said to him, I am your lawyer, but there are certain ethical boundaries that govern the way in which a lawyer can represent his or her client. In many ways, attorneys stand the gap in a civil society. Attorneys sometimes step into very challenging circumstances. Mr. Ouderkirk was involved in one of the most high-profile cases in recent history here in Iowa. And he is to be commended for taking a very bold step and taking some very challenging facts to deal with. However, the disciplinary rules set boundaries within which zeal must be confined. And I believe this Ouderkirk case provides us with some very helpful guidelines in that effort. So as we wind down our time, if you have follow-up questions or comments, you have my email address on your material. Feel free to call or email me. And Christy, are we out of time? We have one question here in the audience. August, what is your question?
On page 20, you have the statement that the court recognized that Ouderkirk told them there might be a possibility that they might be deemed fraudulent. The attorney didn't have the guts not to take the case. How can you kill your neighbor and then your client is transferring all the property and not think about that?
Yeah. Well,
and now he's off free.
Yeah.
This is a case that says everything goes free for the lawyer.
Yeah.
No matter what you do.
Yeah. So can anyone hear these questions? So should I repeat the question? So I mean, the thrust of the question is, it seems that the facts make it implausible that Mr. Ouderkirk could not have asked harder questions given the fact that a wrongful death suit had already been or was presumed to take place. And I appreciate that, and that's really sort of the difficult nature of this case, because reasonable people, I think, can come up with a different outcome. The court made a very extensive review of these facts, and particularly the badges of fraud, and found that because there was only one of these badges of fraud, and Mr. Ouderkirk had taken steps to address that there was no violation of the rules of ethics. I don't doubt for a moment that if Mr. Ouderkirk could do things differently, he might well now, with hindsight, have asked a different set of questions. I think that's probably a given. But we're not judging Mr. Ouderkirk based on those facts. We're judging him like the court does based on the information he had at the time. And you may have a different opinion on the court's outcome, but that's what we have to work with today. So as we wind our time down, thanks for asking that question, though. It's the question that these facts beg. But I appreciate everyone tuning in today and those who are able to attend. I hope this has been helpful, and I wish you all a very happy new year. Thank you very much.